All right, we're here for another installation in our series talking to practitioners about how their perspective on litigating high-profile cases. With me today is Dan Canon, who is a civil rights lawyer in the Louisville, Kentucky area, and also teaches at the Brandeis School of Law, University of Louisville. Dan, can you tell us a little bit about what your practice has been like, what you focus on?
Sure. I am broadly what you'd call a civil rights lawyer. And I do some criminal work in appeals and post-conviction, but mostly what I've done is to litigate against government entities. So lots of police abuse cases and cases brought on behalf of incarcerated people, that sort of thing. I have had a few cases against public universities on First Amendment grounds and on Title IX grounds. And I've done quite a bit of employment discrimination work, but that's the long and short of it. So mostly constitutional litigation, and then broadly what you'd call civil rights litigation.
So I would imagine in a lot of these contexts, you have cases that end up being high profile, end up having a lot of media attention and social media attention, and where the issues are potentially played out in across society. How does that affect the way you practice? What's your perspective on it?
Well, I think, so I'll go back and say one of the first cases that I did was against the University of Louisville. In 2008, 2009, I brought a free speech case on behalf of a nursing student that got summarily dismissed because of the contents of her MySpace blogs, which was a thing then. What I learned the hard way was that media is out there and they are watching the courts and they will oftentimes come after a case that you don't realize is big, right? If it's not like, until you, especially, once you first get into practice and until you develop a nose for this kind of thing, and you think, well, this might be a big case, or this might be something that the media is interested in, you can get smacked in the face with it. And that's what happened to me, with that case was, the whole issue of discipline over social media was very new at that time. Mm-hmm. And so, national and international media came calling, and I was, a very new lawyer and sort of like overwhelmed to have my inbox stuffed with all these reporter requests overnight. And so, I think first and foremost, I would say just be prepared for that. Lawyers, and you don't think of this when you go into it, and we don't talk very much about it in most of your law school classes, but lawyers are in the public eye. Like if you're doing criminal cases, if you're doing civil rights cases, if you're doing just about any kind of cases, there's a very good chance that you're gonna get some media coverage, and you're gonna have to know how to handle that. So I learned the hard way that, after giving a couple of really disastrous interviews, I'm like, okay, I've got to figure out how to, say what I need to say in a very short amount of time, and make sure that I can do some sort of control of the messaging here, so I don't get the wrong little snippet out there and make my client sound bad, or just sound bad, generally speaking.
So your perspective isn't one of no comment. It's not like some of the other ones we've talked to when you're representing a criminal defendant, you may have to engage less with the media. What's your general perspective on whether or not to talk?
Yeah, I think generally speaking, I would shut up about the criminal cases, especially at the trial level. Now, for most of my criminal work, these are criminal appeals. So somebody's already been convicted. And so, you don't really have all that much to lose in the public eye.
Right.
And there's not a problem with ethical rule, 3.6 or whatever it is, where you're going to run afoul, or you're going to influence the outcome, because the outcome's already done.
Right.
But if I were doing a lot of trial level criminal stuff, absolutely shut up. Don't talk to the media. There's not a good way to get through that, in my opinion. But with civil rights cases, I almost think the opposite. I almost think that you have to, because at this point in American history, the courts are so bad that in many of these cases, the best that you can hope for is a victory in the court of public opinion. And you'll see, I mean, you see that if you can win a significant victory in the court of public opinion, that can actually drive real world outcomes in your cases. And I think that's very important for civil rights practitioners to sort of understand that and to know how to use the media. And a prime example of this is the Breonna Taylor case. I have litigated, and I've talked to those lawyers in my classes about this stuff. And I think we're generally on the same page with it. I have litigated like hundreds of police, well, at least dozens of cop cases in Jefferson County. And over the last 15 years, what I can tell you is they are not eager to pay those cases, right? The county is not eager to write a check, even when it's obvious they're wrong, even when it's obvious that they've, killed or maimed somebody that they shouldn't have. They'll fight you every step of the way on that.
Right.
And, all of a sudden in Breonna Taylor's case, even when, the story was that officers were being fired on when they kicked down the door to her apartment, they end up paying $11 million. Well, what's the X factor there? Well, there's two different things. One is that they were smart enough to file it in the state court, keep it out of the federal courts, because the federal courts are terrible. But the other is just the enormous amount of media attention and the way in which that legal team was able to leverage the media attention, leverage that moment in American history to bring the conduct of those officers and the conduct of the county, the conduct of the government, which, by the way, is conduct that's been going on for 40 or 50 years at least.
Have you had conduct in other cases in the area where the police were either comparably bad to the Breonna Taylor situation or worse?
Oh, yes.
That you did not get a multi-million-dollar verdict on?
Yes, many, many times. And what that legal team was able to do was to use the media and to seize that moment to leverage an enormous settlement. I think the biggest settlement in Jefferson County history for Breonna Taylor, and rightly so. But what I can tell you as a practitioner that's been doing this for a long time, and if you talk to other people that have been doing this kind of work in Kentucky and Indiana, is that those checks don't come easy. And if you're going to get any money out of a county, if you're going to get any money out of police around here, you're going to have to beat it out of them. And for the most part, most of those cases are going to lose. I mean, I can give you example after example of that. But I mean, we had a case out in Eastern Kentucky where the guy was summarily executed while he was asleep on his couch. Cop comes around.
How is that different? How is that different from Breonna Taylor? Except in the Breonna Taylor case, as you mentioned, the police were getting shot at.
Yeah, exactly.
So it's almost worse.
Right. And that we had to take that up to the Court of Appeals because we got summaried out in the Eastern District of Kentucky because they'll find a reason to kick the case out.
On qualified immunity grounds.
On qualified, on every ground that they could come up with. And then we had to take that up to the Sixth Circuit Court of Appeals and back down to get even a pittance for the family in that case. And that really is the way that civil rights litigation has been. It's certain to be that way for the foreseeable future because, again, the courts are terrible and getting worse. And so, the only way really to leverage good results for clients in these cases is if there's some X factor out there, if there's something different that you can bring to the table. And sometimes that is media attention. Very often that is media attention. Otherwise you just, and the other benefit to that I'll say too, is that even if you lose, which often in these cases you will, and you sort of have to prime yourself and prime your clients to like, okay, the courts are really bad. We're probably going to lose, but maybe we win. And that's, but if you lose and you still win a victory in the court of public opinion, then that is something at least, right? That is something that can be carried forward and turned into real social change, which ultimately most civil rights lawyers want. That's sort of the goal, is that if we can bring more attention to this, if we can, this particular issue or this particular case, if we can, inspire somebody to do some good thing out there because of what they saw and because they're outraged at the court's decision in this case, then great. So it's a way to salvage something out of what seems like an unwinnable case.
Okay. So you talked about winning in the court of public opinion and using that for social change. And one of the cases you've been involved in that is a massive social change case would be the Obergefell case. which is a high profile case of kind of a different spirit altogether. If you could talk a little bit about your perspective on a Supreme Court case, in that, and every Supreme Court case just about is high profile by definition. How did that impact your litigation?
Well, yeah, it is. And I'm thankful to have had high profile cases prior to my experience on Obergefell, because we sort of knew what to tell the clients to expect. And, I don't know if you can ever be fully prepared for something like that, though. I mean, it's arguably the biggest civil rights case of the 21st century. And so, that of course was a media firestorm. And was, so like total gangbusters of lots of requests all the time. The clients got to, throughout the course of that, the 2 years we were litigating that case, the clients got very good at doing media on their own. And we just sort of fell back on the usual strategy that I would tell any lawyer that's trying to deal with furious media attention, which is, pick 3 different things that you keep coming back to. Pick 3 different messages, get those messages committed to memory, and go back to them over and over and over.
Consistency.
Again.
So we're being consistent with the image or the take we're having in the media. And so they hear that message and it resonates and they associate it with us.
100%. Yeah. And it's not too, and it's like, you're not getting too far off track by trying to answer, some wild question, because you'll get wild questions from the media. And if you just keep in mind that, like, all right, these are the messages that we want to convey in this case. It's this one thing and this other thing and another thing. Get the whole legal team on board with those 3 points, including your clients, and say, regardless of what they ask you, find a way to wander back to one of these 3 points, right? Because otherwise you get too far off track and there's just too much out there, right? There's too much risk of having your words used against you or your clients. But if you can marshal that media attention into, amplifying the message that you want the public to hear about your case, then, I mean, that's a win. That's ultimately what it is you want to do. I mean, I'll say that as much media attention that we had in Obergefell, that was spread out over, a lot of different lawyers over 4 different legal teams. Okay. By the time we got to the Supreme Court, what was really the media firestorm was Kim Davis.
Okay.
And I was not expecting that. Again, you just don't know how the media is going to operate unless you're, really good at that stuff. And I don't think any of us expected, the ACLU didn't expect, that we were going to get the enormous amount of attention on Kim Davis that we did, which, for those of you that don't know, that's the clerk that wouldn't issue marriage licenses in Kentucky after the Obergefell decision. And
so why was that such a firestorm when the initial case was not?
I think because you had, frankly, I think it's because on the other side of that case, you had people that were pretty good at manipulating media.
Okay.
Right. So we're litigating against the Liberty Counsel, and the Liberty Counsel has got lots and lots of experience sort of taking up these conservative causes and getting the right kinds of headlines to happen as a result of those. I say the right kinds of headlines, right, in scare quotes, to happen as a result. So I think that had Kim Davis been, this is why representation matters, right? I think had Kim Davis been represented by, some little mom and pop shop attorney in Eastern Kentucky or the county attorney or whatever, then, the case probably would have been settled quickly. We would have been able to come up with some kind of resolution, and it would have stayed relatively quiet. Once Liberty got involved, then this just became a gigantic media explosion, like nonstop, 24/7 national and international media.
Do you think also an aspect of that case was that one side had a legitimate person to put everything on, to villainize, to demonize? I remember people having Kim Davis costumes at Halloween, whereas in Obergefell, there's not someone for people who don't know, who aren't in the legal system, to focus on. Do you think that mattered at all, that here we had an actual person who was doing bad things against the law and people could look at her and, I don't know, focus differently in the media?
Yeah, I think it definitely matters. Like, if you have a cast of characters that is, sort of salient, like if you have,
Right.
and I mean, you say villains, you say vilified, but I mean, really, what happened, especially when Kim Davis got locked up, is that she was essentially martyred, and
Yes.
so
Yes.
for anybody that was even kind of remotely, I mean, that to me, that was a PR disaster for our side.
Okay.
Like we didn't ask for her to get locked up, and that's not a thing but the judge went ahead and did it because she was in contempt of court, obviously.
Right.
Right. And so I understand why it happened, but it's not something that we asked for. And actually, we're actively working against that. Like we didn't want that
Okay.
because of what it looks like from a PR standpoint. Now it's like she's been thrown in jail because of her religious beliefs. Not true, but that's the story that can easily be told. And the Liberty
Right.
Council, to their credit, recognizes that. I mean, they recognize, well, we've got a case that we can, this is an easy hero for us, for our movement. And we can say, she's being picked on because of her religion, and we can peddle that narrative. And that's an easy narrative for the public to understand. And I think once somebody gets thrown in jail, it's like, all right, and I ask my students all the time in the civil rights class, I'm like, all right, you guys have heard of Kim Davis? Yeah, we know who Kim Davis is. You know what that case is, right? Who's heard of April Miller? Well, I don't know. Who is that? That's our client in the case, right? That's
Right.
that's the plaintiff, like one of the plaintiffs in the case. But people don't know their story, and they're not focused on their story. They're focused on Kim Davis's story.
Right.
So, in my view, that is a big public relations win for the Liberty Council, and something of a loss for us and for the ACLU.
In making her a martyr.
Yeah. In the popular narrative that resulted, even though we won every step of the way, and that's an example of what I'm talking about. Like we won that court battle every step of the way.
Right.
But what's the resulting narrative, and what's the real world outcome? After the fact, I don't know. I don't know that you can call it a victory for the plaintiff when people know who Kim Davis is and what she represents, and they're still talking about Kim Davis, 7 years after the fact. I don't know. I can't say it was a PR win for the plaintiff. That's for sure. And it's hard for me to conceive of that as being anything other than exactly what the result of being anything other than exactly what the Liberty Council wanted, which is an utter media circus and, a resulting narrative that is mostly false.
Right. So as we wrap up, my students are going to be looking at, they've already looked at the David Camm litigation. I remember when I came to this area 12 years ago in an interview, the first thing I was asked about was how I feel about David Camm. And coming from Indianapolis, I didn't know who he was, but it's a local case that's had a lot of media attention over the last 15 years. They've already looked at the criminal aspects of it, but we'll be looking at the civil lawsuit, which you were involved in weeks to come. So if we could just close by talking a little bit about how that particular case, they already know the facts based on last week's material. How did the media impact? And I think when I think of the media attention on David Camm, I think of the fact that he was ultimately acquitted by a jury. And I think a lot of people in this area don't understand that the jury actually acquitted him as opposed to he got off on a technicality. Right. And I think there are a lot of people in this area who still consider him guilty. How did and that media attention affect your civil litigation of his case?
Well, I think it's one of those things of, from my perspective, we didn't really have much to lose by courting media attention in that case, because the more sunlight you get on the actual facts of that case, I mean, I think by and large, when you talk to people that think that David Camm was guilty, it's because they don't know anything about the case.
Right.
You sit down and you talk to them a little bit about the case, and they're like, "Oh my God, I didn't know that." Like the blood spatter expert had never even graduated from college and identified the high velocity impact spatter over the phone. Like, I mean, like there's bizarre facts that happen.
Sounds like high impact to me.
Yeah, exactly. That's what happened.
Yep.
And that's ultimately what put a man in prison for 13 years. And, when you share that kind of shocking information with people, it does tend to change their opinion on things. Okay. But if you just let it sit and you avoid the media, of course, you got to, be mindful of the dictates of the ethical rules. But I think if you just let the media sit and do its own thing and you don't have any involvement with it whatsoever, the resulting narrative is not going to change. And the resulting narrative on the ground, I mean, for me, somebody that grew up in New Albany, everybody thinks this guy is guilty,
Yep.
right? And continues to think that because they don't know anything about the facts of the case. It's not any different than the, McDonald's hot coffee case.
Right.
If you walk away from that whole thing with the McDonald's talking points and only the McDonald's talking points, and that's the only version of that narrative, well, then it's an old lady that, tried to drive off with a cup of hot coffee between her legs, and who could be sympathetic to that? Well, it's similar to David's case, I think, in that he got tried and convicted twice. And then on the third time, well, he finally got a jury that would believe his story and acquit him. And it just simply is not, it is not that simple, right?
Right.
It's a lot more complicated than that. And the more media attention you can put on that, and the more you can get your message about what the case is and what it was, out there, the more likely it is that people are going to start hearing it and changing their mind about the thing.
So that's an aspect of having to redirect the narrative from a place of inaccuracy to one that more accurately helps your client and shows what actually happened once the criminal litigation was taken care of and you could no longer impact a jury pool, things like that.
Right. And if you stay within the boundaries of the ethical rules, there's really nothing to lose by that, right? Because what's equally important to David, or somebody that's in David's position in a case like that, a wrongful conviction case, 99% of the time, what's equally important to getting money in their pocket is that they clear their names.
Right.
And that they really actually, tell their story and really can get their version of events out there and make people understand, the general public understand, that an injustice has actually happened here. David is somebody that got run out of his own community that he served for years, prior to having been thrown in prison. And that community is still, by and large, not willing to give him a break. And it's important to get those kinds of stories out there, even if you ultimately lose on the merits, which, thankfully, we did not in David's case.
Well, thank you, Professor Canon. This was great. We appreciate your time talking about all your cases. If you have any, do you have any last words for my students who are furiously working on a case memo right now for the end of the semester?
Yeah, well, just the thing to keep in mind, folks, is when you're doing civil rights litigation and when you're doing criminal litigation, is the sort of Kobayashi Maru situation. Like, go watch Star Trek and learn about the Kobayashi Maru, because it's like that. It feels like the unwinnable situation, right? And so what you have to be able to do, I think, especially with the courts the way they are now, is to be able to figure out creative strategies to win, even when you lose. Even when you're certain you're going to lose, you have to figure out strategies to do that. And a good media strategy is one way that you can start to approach those kinds of solutions.
That's great. Thank you so much for your time.
All right. Take care.
You too.